policy advisor over here at the Commission. And I am going to kick us off today. We sent around a very abbreviated agenda. And so where I would start is we're here today to talk about some of the ideas that the Commission staff are thinking about in the context of the upcoming Flowline rulemaking. At the end of Mark talking through staff's kind of thinkings and issues that we're considering and weighing at the current point in time, we'll talk a little bit about the timeline that we're on. Again, we're shooting for a November hearing date, which is not that far away, but I think with the hard work of everybody in this room, we'll be sure to get there in a meaningful way. So the rulemaking today is in very direct response to the changes of Senate Bill 19-181, which directed the Commission to undertake 4 specific rulemakings in advance of removing objective criteria from its permit review process. I don't want to delve into the deep weeds of what that process means or what objective criteria are right now, but if folks in the room or on the phone have questions about that, we can certainly take them up either at the end of the meeting or at a different point in time. We look forward to hearing from you questions, comments, concerns once we kind of run through the presentation. But with that, I will ask that I hope that everybody signed in, that you have your cell phone off, and that you're ready to have a robust conversation. And I will turn it over to Mark Schlagenhoff to walk through what staff is thinking at this point in time around ideas or concepts for the Flowline rulemaking that we're embarking upon.
Hi, I'm Mark Schlagenhoff. I'm the Engineering Integrity Supervisor here at the Commission. Some people may remember me from the previous rulemaking in 2018. And we'd like to thank everyone for participating today because I think last time the input from various stakeholders was really valuable to the Commission and to the rulemaking. Okay, we're gonna start out with a mapping discussion. In the last rulemaking, we also had some discussions on the mapping, so some people may remember that. SB 181 discusses the public disclosure of flowline information. So this would be typically off-location flow lines, crude oil transfer lines, and types of data. We have electronic data that we have submitted in geodatabase. We've asked Chris Eisinger to be here because he's our geodatabase specialist. So he is quite involved in that particular aspect of it. And then also we wanted to talk about whether there's a need to have greater requirements in drawings such as built drawings, which would take into account if there were changes in the construction plan. So we would have a final as constructed drawing that would have all the specifications and would give us something to base our inspections on. Just to review for the people who aren't familiar with what an off-location flow line is, typically a good example is what we have here, where people have put multiple wells into a centralized production. And so as opposed to having your production right at the well site, you have one common production facility that multiple wells are using. A crude oil transfer line, this is when you have multiple wells feeding into a midstream liquid line. Some of these are regulated by PHMSA, some are regulated by the Commission. So what we're proposing is to create a public layer of the COGCC regulated lines. You're familiar with our database on the website. So we would just have a layer where you could call up the flow lines. Pardon? Yeah, it would be on the map. If you are familiar with the COGC map, see a GCC map on our public website. So that's how we would envision it would work. If you want to have a better idea, this is just an example of what the federal government does. People may want to look at this website. This is from the National Pipeline Mapping System. And this is the PHMSA lines, which are put into a public mapping database. And you can turn on and off the gas and the liquid individually, and that's what this menu on the side is for. So we just want to put that up as an example of a mapping layer. Okay, so that was mapping. We wanted to talk a little bit about setbacks. PHMSA has some setback rules in their regulations. So this would be looking at crude oil transfer lines and some off-location flow lines. One of the things to keep in mind with the PHMSA regulations is that they're divided up into separate rules for liquid and gas. So they have sections 192 and 195. And so sometimes the rules will be the same or similar, and sometimes they'll be quite different. In this case, they're different. So for the liquids, they're focused on the depth of cover and the distance. Whereas the gas, they have a formula, and I put radius in here. I think in their actual formula, I think it's diameter. But basically the gist of the gas setback is if you have a bigger radius or diameter pipeline, then your setback is bigger. And if your pressure is higher, then you would have a greater setback. So that is the formula. So it wouldn't be a fixed distance. It would vary depending on the operating conditions of the pipeline for the gas lines. Okay, we wanted to review where we are. We're currently in the process of building a database. So we've had some public outreach. We've talked at the operator meeting that we have a deadline coming up of October 31st, 2019. So the new flow lines which are built are supposed to be registered within 30 days of construction. The previously built ones prior to May 1st are supposed to be registered by October 31st. And here's the registration data we're currently collecting, which would be the riser lat longs, bedding materials, pipe materials, maximum flow line diameter, fluids, anticipating operating pressure, test date and chart, layout drawings, and we're looking for the oil and gas locations. For the produced water transfer system, this is just a diagram of what they would look like for some typical basins here. We have a lot of water in the coal bed methane areas. You see here Raton and San Juan. So there's some complex networks of flow lines moving the water, also in the Piceance. So here's where we are in terms of statistics. We've approved almost over 4,100 Form 44s. People have submitted over 1,400 that we haven't done anything with, and then we have, let's say, a partial review of 131. Here is our current mileage of flow lines. You can see the biggest one is off-location flow lines, but we do have some hundreds of miles of crude oil transfer lines and produced water transfer systems. That total mileage would be over 6,000 miles of pipelines in our system right now. Okay, now we're going to talk about integrity management and SB 181. Requires us to evaluate and determine when a deactivated flow line must be inspected before being reactivated. One of the things here, we get some questions on the initial pressure test as opposed to the tightness test that people are doing to see if a line has any leaks. So typically the ASME pipeline standards and the API pipeline standards specify a minimum of 4 hours. So we're considering putting that into the rules. If people have an inactive line prior to them being used again, we'd want an integrity test. We're talking about a notification that a line would be reactivated, and we're also reevaluating the frequency of integrity testing. Okay, on abandonment is covered in Rule 1105. So if it's not an active use, we're going to call it out of service lock and tag. We'll talk a little bit about this later, but basically OSHA has an explanation on their website that the official lockout tagout is only to be used for maintenance and repair. And so we want our rules to be consistent with the OSHA interpretation. So we're going to use a little different language for that. So for abandonment, we want the line separated from all sources of fluid and pressure. And the last rulemaking, we introduced the concept of removal of the flow line as a allowed practice. Prior to that, we had just mentioned abandonment in place. So we're going to take a look and see if we need to provide some additional information there in the rules, considering removal or abandonment in place. We're also going to look at when people do the abandonment work, to submit additional documentation to make sure that the abandonment steps were done properly. We plan to make it an inspection priority to the extent possible with the manpower we have and whatever manpower we get in the future. And typically we provide the abandonment report to the local governments and also the call before you dig program. Okay, some additional steps we're looking at. In the previous rulemaking, we introduced the ASME standards. They also have a repair standard, ASME PCC-2, which we're considering to reference in the rules. In the rules, we do talk about tracer lines. So we're considering adding corrosion protection as a requirement for tracer lines. In the last rulemaking, we added the specifications for the fiberglass lines. There's a low pressure and a high pressure, but we did not mention the RP15TL4, which is an API standard on has more to do with kind of the operational aspects of it. So we're looking at adding that. Another issue, if people have above ground lines near the road, there's a risk of damage to the pipeline from a road accident. So we're considering adding a barrier requirement. PHMSA has a similar requirement in their regulations. Some people have said they didn't like our signage rule because it was slightly different from PHMSA. So we thought about referencing the PHMSA signage rule so that if people have lines that are regulated all or partially by PHMSA, they could just have one set of signs. We're going to talk a little bit more about stormwater, open excavation, and securing sites, maybe in line with what CDOT type requirements are, because we have had some issues where people, they kind of start to do some work on a site and then the crew gets called away or something, and we've had some sites where the fencing comes down or it's been an open excavation for quite a while. So we wanted to address that. And another thing we're considering is use of excavation tape 1 foot above the line. And that way, if someone is digging, they would contact the excavation tape and they would know that there was a line a foot underneath. We also wanted to look at terms of leaks, especially what CDPHE is doing, and see PUC, which follows the PHMSA requirements. I guess ideally it would be nice if there was just one form that would cover a reported leak from every agency, but everybody has slightly different requirements and reporting forms. And so we kind of wanted to look at what the other agencies are doing and maybe make things a little more consistent across the board. CDPHE has a lot with gas leaks, and PUC has certain requirements if a significant volume of gas is released. One thing to keep in mind is that off location flow lines, it's very common to have reportable spills because we're outside containment and it could impact waters of the state, residences, livestock, or public byways. So we want to look at the off location flow line reportable spills and whether the spill investigation and cleanup provisions need to be strengthened. And just a reminder that root cause and preventative measures, we do mention cause and preventative measures in Rule 906D2. We may want to strengthen that because in a lot of cases we're still not getting reporting of the cause and actions operators are going to take to prevent the reoccurrence of the spills. I want to give a reminder to everyone that earlier this year we completed the Flowline instrument monitoring method work group studies. So that information is on our website, and that may be useful if we're going to talk about leak detection issues. We covered both liquid leaks and gaseous leaks and the applications of instrument monitoring in this work group. There's some things in the last rulemaking that we want to revise. When we set up the 811 checkbox or information on the forms, we kind of had it where people would give their operator code, and what we really needed there was a checkbox just to say, are you a member, yes or no? We really don't need the code information. The other issue to keep in mind is when we think about an operator, typically we think about someone who operates oil and gas facilities, but the way the COGCC defines it is if you're a financial assurance provider or a trucker, you're also registered as an operator. So we're going to have an NA category that would cover those types of organizations that would not have to register for the call before you dig. PHMSA has come out with some new proposed categories for piping, for pipelines. Pre-commissioned is one of them that I think will be of great interest to the Colorado audience, because often we've seen operators come out and they build facilities and later on they're going to drill the wells. So this would be covering the flow lines that were built, was a plan to put them into service at a later date. We also have active in service, inactive out of service, and then abandoned. One of the things PHMSA is looking at for the inactive out of service is a possibility of requiring an inert gas be used in the line before it could be considered an active out of service. So this is something we're following closely. Okay, conforming changes. I talked a little bit about the OSHA requirement where it's only maintenance and repair. And so we're looking at a new definition of USLOT, which is short for out of service lock and tag, to cover that category. Another issue, earlier this year, we added a variance possibility where people who had complex networks of flow lines could do a bulk download instead of having to register it point by point. And this is especially of interest to the larger operators or people who have a lot of flow lines. So we would officially make this part of the rules. Right now on the form, if you do bulk download, it says variance, because it's currently set up as a variance from the rules. So we would make the bulk download part of the rules. We go to the 200 series where we talk about GPS data. And at the time where we did the rules for GPS data, there was something called PDOT, which was a measure of accuracy, which had to do with how many satellites were overhead, and it's not really used anymore. So we're going to update that GPS definition, or that how that's written. And this has been an issue for a lot of people over the years doing GPS data. So we're finally going to get around to updating that. People are doing comprehensive drilling plans. We think it would be a good idea to discuss the crude oil transfer and produced water transfer lines, because these tend to be longer lines that might be of interest as part of a plan. Okay, 600 series or the 900 series. As you may recall from the previous rulemaking, we added reporting for grade 1 gas leaks. And at the time we were doing the Flowline rulemaking, and so we put it in the 1100 series. And so it looks like it only applies to flow lines. And so we think if you have a grade 1 gas leak, which is one that could potentially be dangerous to public health or safety, that it should apply not only to just flow lines, but to any type of gas leak that you have. It should be reported. And so possibility we could move it. We wouldn't change the regulations themselves, but whether should it be housed in the 600 series, which is safety, or the 900 series, which is EMP waste, is under discussion. Finally, in the 700 series, where we talk about financial insurance, there's a little confusion as to the gas requirements and the produced water requirements. And so we kind of put them all in the same paragraph, and we're just going to break them out into separate separate paragraphs so people can understand that there are separate requirements and that they can't do a bulk financial assurance for each line. We also have gas gathering registration requirements on the Form 12. And right now we just ask for a layout drawing. We kind of like to be consistent across all the pipeline forms. So we're looking at adding a geodatabase requirement on the Form 12. And the rulemaking timeline that we're looking at, today is the first day, and we'll file the notice of hearing on October 8th. We're going to have another meeting October 9th. The pre-hearing process will be October to November, and we plan to have the rulemaking November 20 to 21. So it's right around Thanksgiving, so you can give thanks about the new rules. And we're on to the questions. Julie or Mimi, do you have any other?
And just to reiterate that these are the ideas that we're certainly taking a hard look at. We would welcome other thoughts and comments on these rules or other pieces. And with that, we'll open it up to Q&A. And I see a gentleman. Enrique, the gentleman in the back. We'll try.
It does not include gathering lines. Gathering lines are currently regulated in Colorado by the Colorado Public Utility Commission's Gas Safety Group. We do have a registration on the Form 12 for gas facilities. Yeah. The question is, do off-location flow lines, are they gathering lines? And it's a separate category. And if you want to look at how that's broken up, API does have a API RP80 does discuss where gathering lines begin and where they end, and PHMSA references that currently. And it's not always easy to say where the gathering begins and where it ends. So sometimes you need to go ask for an interpretation, and I've gone over with operators over to PUC and say, let's put all the heads together and discuss it and decide how we want to register the lines.
Mike Chiropoulos, and I just wanted to raise the issue, Mimi, that I contacted you about. We weren't able to talk before today, but I'm working with some groups who are concerned with wildlife protection aspects related to flow lines. And the concern is whether we engage in this rulemaking and raise issues that it seems to me pretty clear are outside the scope of what's currently anticipated, a focus on health and safety and technical aspects. And we just want an assurance and direction from the commission that if we don't engage and advocate for wildlife protections in the context of flow lines and gathering lines and transportation infrastructure here, that we'll have the opportunity to revisit any aspects of these specific rules in the wildlife protection context in specific future rulemakings. And I've reached out to some of the industry council and environmental colleagues, so I just wanted to put that out there to get some feedback on so we know where we're at and everybody else does in terms of scope.
Thanks, Mike. I think it'd be helpful to sit down and hear the specifics of what your team is thinking so we can understand it and take that information in.
Great, appreciate it, and we'll follow up. Yeah, thank you.
Thanks. My question is a little related to the first. And Mark, there was a slide, I think it was on page 4 or 5 of your deck, that showed crude oil transfer lines and sort of a schematic of those.
You want me to go back to that?
If you could.
We have a question on crude oil transfer lines, so we're going to go back to that slide.
And while you're getting there, I guess my question is, the revision being proposed to mapping would have the public layer of the commission's map showing commission regulated lines on COGIS or the mapping program. And so I wondered if you could sort of talk through that in relation to this slide and say which would be in and which are out and which might be shown on the PHMSA site that you showed on the next slide.
Okay, the question is on the crude oil transfer lines and how they would be represented on the mapping layer. The crude oil transfer lines tend to be larger midstream lines, and typically if we would regulate them, they would generally lead to a larger crude oil line that's regulated by PHMSA. So we would expect, typically here, you can see we have a number of pads which are transferring over to this crude oil transfer line. We would expect the crude oil transfer line would show up on the layer. Likely that these lines from the pad to the crude oil transfer line would also show up on the layer. I would expect as off-location flow lines to the crude oil transfer line would be my interpretation, how we would handle that on the mapping layer.
So like, Mark, correct me, but my sense is that if it is an off-location flow line, that we are regulating whether it's a crude oil transfer line, produced water transfer system, or an off-location flow line, we would map it.
Yeah, if it's regulated by COGCC, it would show up on the layer is our expectation. And that's when we did the registration statistics, you can see here, that's what we're collecting data on. So the expectation is we're currently building the database. We're reminding people of the upcoming deadline, and then those forms that come in at the 30th of October, there'll probably be a time lag. They won't all be approved by November 1st. So there will be a time lag after October 31st before all that information would be in our system. And at some point after that, if this rulemaking goes forward, then the layer would be public.
Well, okay, yeah, so mine's a follow-up to that question. Has any thought been given to expanding from what COGCC, to only including what COGCC regulates, to be a little bit more broad in what the public can have access to? I'm particularly referencing gas gathering infrastructure. As you yourself said, Mark, that it's hard to know what's what, and it's not always immediately clear to members of the public what's what. And there are thousands of miles of gathering lines in Colorado that don't have a map anywhere at PHMSA or PUC or COGCC. And I share your concern with having one place, one form, one thing. And this rulemaking seems like it'd be a great opportunity to expand what's being reported to the COGCC and what the COGCC is reporting back to the public. And gathering infrastructure would be great to have on that map.
Thanks. I think the COGCC is constrained by its regulatory authority on that front. And I mean, we can talk to our co-regulators to the extent that they have mapping information that they are making public. We could see about getting that into our system. But I want to be fairly cognizant of different regulatory regimes and the scope of COGCC's authority in pursuing that piece in particular.
And I just want to mention that In terms of gas gathering, we do have the Form 12 registration, which does have a layout drawing with it. So you can go search for that information. And if you look at the one slide where we discussed the Form 12, we did mention the possibility of adding a geodatabase to the Form 12 requirements, which would facilitate the possibilities of making the gathering information part of the map layer at a later date.
Deja vu all over again, as Yogi would say. We were involved in rulemaking back in 2018. We recommended then that you add all gathering lines, which you didn't do. It caused me to do a lot of research with the federal government as to what their program was. They have no program. They have between 20 and 30 inspectors for the entire West, and that includes Alaska. Now, I look at the law here, page 2. It requires you to measure and monitor all gathering lines, all underground storage reservoirs, all supply lines, all transmission lines. You narrowed this thing down so much it doesn't make any sense anymore. The responsibility now is to protect public health and safety. And that includes and must include the idea that you have to monitor all these things in order to be able to prove that you are protecting public health and safety in the environment. You can't do that with this program. You've got this thing so narrowed down that next time you'll have hangnail inspectors and nobody will show up. You've got to broaden this thing. Major changes were made in this law. Recognize it, accept it, get after it, please.
Sir, could you identify yourself, please, for people on the phone?
Well, I know why. I'm Phil Doe. I'm with Be the Change.
I'm Wes Wilson with Be the Change, and I just wanted to give you a bit of history on substantial risks associated with gathering lines and processing facilities. I have here some 30 pages of summary from Bob Arrington. He's a professional engineer you're familiar with. He's on the Garfield County Energy Advisory Board. Some of the highlights include that major spill at the Parachute gas facility in 2013. And then Williams Pipeline Company had significant spills with VOC releases that were substantial from their gathering line system. So what my colleague is saying is, we think you're misinterpreting. The law doesn't say that as a result of PHMSA having some jurisdiction, you do not. The law says that the Oil and Gas Conservation Commission now has jurisdiction. And given the paucity of inspectors available for rural gathering, this is an obligation you have for rulemaking imposed on the commission. So what we would expect as a minimum is that this November rulemaking be immediately expanded to cover the gathering lines, the transmission facilities, and the underground storage facilities. Whether or not there is some PHMSA or some partial delegation by PHMSA to PUC. Thank you. I'll give you that. Thank you. This particular copy I have here doesn't have the color photographs in it. It was too cheap to print them. So I'll give this to you, and it gives you the location where you can go on the internet and find this full report.
Do you by chance have it electronically also?
Yes, that's the first thing in the sentence.
If you could also submit the color copy version to us, we have an online portal to submit information. And so if you could submit it to that information, that means we'll get it electronically, and that would be help me
Okay, I'll
save
do
me the
both.
steps of trying to
I'll
figure
give
out
you this
color
hard
again.
copy, but it lacks the color photos.
Thank you.
I'm Lance Estrela, and I had some questions as to whether the consideration is going to be given to not allowing abandonment of flow lines in place. The two concerns about that are this, particularly with the older lines. If there's pollution and it's abandoned in place, you don't know, you can never find the pollution. So the rule allows hiding of pollution if the lines are not removed. The second problem is this. Some of the old lines, as the commission knows, contain naturally occurring radioactive material and asbestos. If those are abandoned in place, that becomes the responsibility at some point of the landowner. Whether the land's going to be developed or it's a municipality and it belongs, responsibility is with the municipality, particularly acute if the landowner doesn't have mineral rights. So the removal and of the abandoned flow lines, if they contain those materials, and the taking them to a classified landfill is a very expensive proposition. And I do not think that is covered by the blanket easement in the lease because they're no longer used. Thank you.
Thank you, Mr. Estrela.
I'm Scott Yenzer from Peregrine Engineering. I've got a quick question and then a quick comment. The first question is these rules, which to be honest, as a civil engineer and doing pipelines for 30 years, seem very reasonable. I like that. My question is, how do they relate to the rulemaking that happened in the last administration with Hickenlooper? Are these additive? Are these, or are they part of what was implemented a year ago? Then I've got a quick comment.
Yeah, I think a lot of times when you do a rulemaking, afterwards you do kind of a rule cleanup, and some of this, like I talked about, the out of service lock and tag is due to the OSHA interpretation. So that's kind of a cleanup of the old rulemaking. And then there are some new things added to correspond with the SB 181 requirements.
Thank you. And then if you're open to advice, I'm speak to you as a person that's doesn't have a salary coming in right now, and specifically because I work for a pipeline construction company. Our clients pulled back significantly in Q1 and Q2 because of uncertainty of what's going to happen in Colorado. Because of that, our revenue dropped. I couldn't be afforded anymore. So there's direct implications of 181, or even the threat of 181. People were worried we don't know what's going to happen, and they just pulled back. They just held back. So I implore you to consider this in your rulemaking, that you, if you're going to do rulemaking, make it clear that there is some consistency so that the developers and the people that are putting pipelines in place know that there's not impending chaos, that there is something that they can point towards. And the fact that you're aligning with PHMSA, something that is in our backyard anyways, that's great. But I implore you, as you go through this process, just get the message out that there is going to be consistency, that there's not going to be random rulemaking. That'll make a huge difference in investment in Colorado and the interest in people putting flow lines in and taking the dangerous materials off the roads. So thank you.
Sorry.
Yeah, I just kind of wanted to respond to that and point out the how families and people living near this are also really, they don't have any consistency because these things are going in all the time, and the fact that you can abandon them in place, and we're trying to make rules about how to make that safe. I mean, I feel like if a company puts those in and then they abandon them, they need to remove them. That only makes sense. And you also said in your presentation that, when you're talking about leaks, you said off-location flow lines, that reportable spills are common. Well, that's just like a red flag right there. It's not like how do we make that a little less bad? It's like, how do we avoid that at all? So I think, I'm sorry if companies are concerned about the infrastructure they put in and that they, maybe don't have enough money to take it out when they're through with it. But there are people that are living here all the time. So I think you need to just reflect on that, not just try to make it a little less bad, but to help this problem totally.
Ma'am, can you identify yourself for the folks on phone?
Yeah, my name is Barbara Millsbury. I'm with Be the Change.
Hi, Jan Rose. Just a point of clarification, did I understand that one of the things modified under financial assurance will be separate bonding, one for the conservation fund and another bonding requirement for the environmental fund?
It's right now the rule requires bonding in the same paragraph for two different categories of facilities. And so the idea is to break them into separate paragraphs to make it abundantly clear that it's separate bonds for separate facilities. That's the consideration.
Okay, so there was a single bond that that assured both of those requirements, and now you're just going to do two bonds, one for each.
Staff has interpreted that you need one bond for each today. Okay. So it's, to me, the intent would be to clarify that, but again, we're soliciting stakeholder input on that particular topic.
Thank
also.
you.
Yes, I believe.
Thank you, John Brackney. Appreciate your work. If the staff can do the broader business community a favor, industry professionals probably get this, but the broader business community in trying to figure out the regulatory environment, we'd like to know what's mandatory by Senate Bill 181, what's thou shalt do, what shall be considered, what's suggestive, and then what's maybe a technical fix or a staff-oriented decision. And I know we might be able to argue about all three of those and which one it is, and maybe there's other categories. But it'd be nice to know under specific segments. I'm sorry, we may or may not like this, but the legislature told us to do it and the governor signed it, so we're doing it to the best of our ability. Or here's something we'd like you to consider because the legislature didn't consider, or it's purely a technical fix that there's really nothing to worry about. The reason I point that out is, as some of you may know, just yesterday, the CEO of PetroShare, Colorado-based company, just announced Chapter 11 reorganization, and the CEO specifically said the new Colorado regulatory environment governing oil and gas permitted the state and associated uncertainty. The rulemaking has made it very difficult to attract new capital investment in this sector. This is real, and it's beyond the oil and gas industry. It's the broader business community is extremely concerned about this regulatory environment, and we ask you to take that into consideration.
Thank you, Mr. Brackney. Other questions, comments from the room about the attentive hand in front?
Yeah, this is Dave Neslin. And again, let me echo what some of the others have said in thanking you for your work on this project, particularly you, Mark, and you, Julie. It looks like the schedule that you put up is still evolving somewhat, although we're trying to get to a hearing in November. But it also sounds like this is a rulemaking that's going to involve a number of technical and complicated issues, adding a new mapping layer, new integrity management requirements, new construction repair standards, potentially setback requirements, and so forth. And those are topics that's going to require more extensive conversation with witnesses, and in particular technical witnesses on the part of the parties. And so I just want to suggest we all will want to ensure that there's sufficient time built into the schedule so that the parties will have time to vet the proposed rules when they're issued and brief the issues and formulate alternative suggestions where that's appropriate. and then respond to the pre-hearing statements that other parties submit. And I understand we're just at the beginning of this process, but I'd simply ask the staff to continue to take a look at this schedule as we move through the stakeholder and scoping process and the draft rules are prepared, and make appropriate adjustments before you publish the draft rules so that everybody understands what the time horizons are and everybody can participate efficiently. I think that's going to be in the best interest of all of the parties and help all of us ensure that whatever amendments are adopted are appropriate and have been fully vetted. Thanks.
Thanks, Mr. Renzel.
Sorry, I just got texted a question.
Please identify yourself, sir.
Oh, sorry. My name is Andrew Portis Goodmanson. I didn't catch it in the presentation, but could you just talk real quick about how the 811 legislation relates to this? Did you mention it in the presentation?
I'm sorry, the 811 legislation passed 2 sessions ago.
So the question that I got texted me was, how does this involve the 811 legislation?
It'd be helpful. Maybe we can have a quick confab afterwards, have a more specific conversation to make sure I accurately answer
Okay,
that.
thanks.
Mike Wallace with API. Are you going to put a similar caution alert on the mapping that's going to be available to the public on the flow lines, that this should not be used for locating underground utilities and only the 811 program should be used for that purpose?
That's good feedback. Mr. Paulus will make a note of it. Questions, comments in the room? Seeing none. Oh, couple more.
Please identify yourself for the folks on the phone.
Sure. I'm Anita, Innovative Compliance. My question is regarding the slide on the setbacks, what you're calling the setbacks, and the use of the PHMSA, the PIR is what I'm assuming for the gas lines, the diameter and pressure calculation, and then you mentioned something on the crude oil lines for depth of cover and distance. How are those going to be used when you're calling them setbacks? I know that's not quite how PHMSA uses them. They use them more for determining risk and also for design criteria. Are you planning on using them the same way as PHMSA or using them in a totally different way?
Okay, the question is about the PHMSA setback. So basically, in particular, we were looking at the gas lines and where you have the possibility of, if you have a larger, higher pressure line, you don't want to have buildings nearby. So we were looking at it in a similar way to PHMSA on the gas lines. On the liquid lines, they do specify it's a totally different concept having to do with a deeper burial of the lines. So we'll have to, decide, do we want to go as a PHMSA route, or do we want to go a different route on the liquid lines, on the oil lines?
I guess I'm still a little confused on how COGCC is planning on using this information, because I think PHMSA uses them more for, they don't use them for setbacks, they use them for risk, determining risk, and also for design of the pipeline criteria. You have more buildings close to the pipeline and criteria to do that pipeline. Is that how you're looking at using them here, or are you specifically using them for not allowing buildings in a certain distance?
I think those are really helpful questions for us. And part of the stakeholder process is hearing questions from a number of different perspectives and taking input. And so it would help me at least to have more dialogue on that point to understand your question and your thoughts and your recommendation, as well as any of the other parties or folks who are interested in engaging. So
I'd just like to make a couple of clarifying statements.
Pardon me, sir. Can you please identify yourself for the people on the phone?
No, I'm Phil Doe. When I talked to the feds, they said they did not inspect gathering lines. The only people that inspect gathering lines in this state are the PUC, and they only do it in an urban environment. There are 10 underground storage reservoirs in the state. Think Aliso Canyon, if you'd like. They have no inspection protocol at all. We asked over and over again during the legislation to have these included, and they are included on page 2. You are simply ignoring them. We have no animus against anyone. We're only interested in protecting public health and safety, and that's what this law is about. So I believe you have to include those. And you have to get off the snide here. You just have to. This is a pretty broad change in the way you do business. And you are now responsible for putting rules and regulations together to measure and all these infrastructure, all of it, including transmission lines. And nobody else has the manpower or the right to do this except you all. And you need to get after it. And to narrow it down doesn't help us much. I mean, we're 6 months into this and you did a rulemaking on 500, you find out you couldn't do, and now this very narrow rule on transmission, or these small flow lines, these 2 to 3 inch lines. I mean, we're not getting there, folks. I'm pretty old.
thank you, Mr. Doe.
Stuart Nyholm, ACTAN. How much say will the counties or local governments continue to have in the placement of flow lines and gathering lines? And second question is, what will be the process that they will be notified of proposed lines?
I'll make note of your question. I don't recall exactly our notice process for new flow lines to local governments, but I think that's a topic worth having further discussion about.
Thank you.
Hello. I also thank you very much for all the thought and effort that goes into your work.
Ma'am, can you identify yourself for the folks on the phone, please? Will you identify yourself for the folks on the phone?
Marsha Kohler. Yeah. A question or a thought concerning all that has been said regarding abandonment, the capping of unused lines and so forth. Particularly in situations where bankruptcy, dissolution of certain companies, oil companies occurs, and they can't afford to take care of this process. It's my understanding that there is insufficient bonding in place. Who pays for this, or how does it get done responsibly? Is that a concern? Does that make sense?
Yes, ma'am.
Thanks.
Yeah. I think we've probably merged the Q&A and the public comment session. So to the extent that anybody's been holding back on either, please jump in. And I promise we'll get to the folks on the phone too. We're just trying to clear the room, I think.
Both Andrew Forkus Goodmanson again. I was holding my breath for the public comment period as well as the questions. And so I had a couple of thoughts that echo some of what's been said regarding gas gathering lines. And I have a couple of, so I want to tell you really quickly why I keep talking about gas gathering lines and why doing something about them, whatever format we decide to do about them, is really important to me and my organization. I represent an organization on the West Slope that's concerned about oil and gas development. And I look through what COGCC and the PUC do regarding inspection and regulation of gas gathering infrastructure. And it kind of scares the crap out of me. There are hundreds of miles, as I mentioned in my comments, just in like our little area in the North Fork Valley, of pipelines that are sort of subject to PUC regulations, but exempt from a large majority of them. The PUC itself talks about jurisdictional versus non-jurisdictional pipelines and gathering lines. And I just got an email today from somebody at the PUC where I'd asked for some inspection records for some of these pipelines, and they don't have them. And it's because they don't exist. And they're only required to report incidents that required large scale evacuations or road closures. And that's a problem when we're in remote areas like the North Fork, where it might be 10 miles from a house, but there's a stream that irrigates, 30 acres of organic agriculture, that crosses right over the pipeline. So we're really concerned by the fact that nobody is paying attention to these gathering lines, and SB 181 did give you some authority to address them. And so I hear your concern about not wanting to cross jurisdictional paths with PUC. So I'd urge you to consider entering into some sort of agreement with PUC that allows you to inspect pipelines that they might regulate, or to share regulatory authority, to do something to get people, if not necessarily on the ground, at least in the air over it. When we're talking about LDAR and mapping, this stuff's important in rural areas just as much as it is in urban areas. And so try and figure out how you can use the authority that you've been given here with PUC to address gathering infrastructure that crisscrosses some of the most remote and beautiful places in Colorado. And I hope we can do that during this rulemaking.
Thank you, Mr. Brooks Gunderson. I'll take another look at the bill and the comments from Mr. Doe and Mr. Wilson.
Hi, this is Anita Cuevas again. I just wanted to say that I know PHMSA is looking at regulating gas gathering lines that are currently not regulated. There's a rule out there, the gas tanker rule. It's supposed to be coming out proposed next few months. So that may some of the concerns there, because it's my understanding gas gathering is under PHMSA and PUC jurisdiction. And so I think they are trying to address some of those.
Thank you. I'm Bob Randall. I'm here on behalf of Erin Martinez. Ms. Martinez provided comment at the commission hearing in Glenwood Springs on August 21st. And there she talked about mistakes that were made by oil and gas and not checking the flow line that ran 6 feet from her home. She identified a few items there that are important to her in this rulemaking. That flow lines that are no longer needed are removed entirely rather than being left in place. That shut-in wells and associated flow lines are inspected and tested before they're reactivated. That flow line leaks are identified and repaired in a timely manner, and that the public knows where flow lines, abandoned wells, and other oil and gas facilities are located. I'm here to add to those comments. Generally, we support the direction the staff set out in the August 27th summary, and we thank you for your efforts. We appreciate the attention the commission appears to be placing on the mapping of flow lines, and we will look forward to working with the commission and with industry to ensure that the mapping requirements are transparent and workable, both for operators and for the public. Second, we're pleased that the commission staff is inviting input on the important issue of abandonment of flow lines. We support the commission prioritizing inspection during flow line abandonment, and we also support requiring the removal of flow lines that are no longer needed. Removing these flow lines is absolutely vital to ensuring that they can't continue to be a conduit for oil and gas. We are rightly concerned that regulatory requirements for in-place abandonment of flow lines are not entirely effective. The requirement to disconnect flow lines from wells, purge them and seal them at both ends has been in place since the mid-90s. The requirement to cut off abandoned flow lines 3 feet below grade and seal them has been in place for the last 15 years. Yet we all know what can happen if these flow lines are not removed. We're also pleased that the staff is proposing to revisit leak detection requirements. There have been technological advancements, and we support modifications to the rules that can take advantage of those. We are, however, disappointed by a few things that the staff summary fails to address. We're disappointed that the staff summary it discusses only flow lines and fails entirely to address wells that have been inactive, shut in, or plugged and abandoned. The directive to the commission in 3460-109-19, as modified in Senate Bill 181, is to, quote, review and amend its flow line and inactive, temporarily abandoned, and shut-in well rules to the extent necessary to ensure that the rules protect and minimize adverse impacts to public health, safety, and welfare in the environment. Yet the staff's proposed revisions fail entirely to address rules applicable to inactive, temporarily abandoned, or shut-in wells. As anyone who listened to testimony on Senate Bill 181's changes to this section knows, those provisions were included precisely to prevent the circumstances that led to the explosion of Ms. Martinez's house in Firestone. We ask that the commission staff develop proposed rules that require notice to surface owners and nearby property owners when wells that have been inactive for a certain period are reactivated, require shut-in wells to be pressure tested when they're reactivated, require reinspection of wells if they've not produced for a certain period, require wells and flow lines to be located, pressure tested, and inspected when they're sold to another operator, and require inspections and testing of plugged and abandoned wells and flow lines that have been abandoned in place. Dealing with how wells are reactivated is vital to fulfilling the statutory direction. We therefore ask that these topics be addressed in the next version and included in the draft rules that are published in the register later this fall. Thanks for the opportunity to provide comment.
Thank you, Mr. Randall.
Wes Wilson with Be the Change again. As you're probably aware, it's the industry and the industry alone looking for pipeline leaks. Much of that is done by helicopter survey. There's reason to believe there's underreporting by such contractors to the industry. We think these rules ought to consider the commission itself, the state government, implementing an aggressive program for aerial monitoring. We need it to come from the state. We need leak detection to be routinely accomplished by the state and reported to the citizens. It's unreasonable to expect the industry to accurately and fairly report. So take that under consideration. We may submit it as a separate proposed rulemaking for your consideration.
Thank you, Mr. Wilson. Hannah, do you want to open it up to folks on the phone?
Yes. So I have a question from Courtney Roseberry with La Plata County. Will the public database layer on the COGIS only show location of flow lines and the transported material, i.e. gas, oil, produced water, or will it also show size, pressure, etc.? Just curious what data will be public.
I think those are the types of questions that we're really soliciting stakeholder feedback on. So if La Plata County has a particular perspective, we look forward to hearing it.
The next question is from Leslie Weiss. How do we sign up as stakeholders if we are participating remotely?
There's no real need to sign up as a stakeholder. It is open to everyone who wants to come. In terms of requesting party status, that will come at a future kind of filing, and monitoring COGCC's Flowline rulemaking webpage would be the best place to get the most up-to-date information. And I believe also Ms. Larson will continue to send out emails. If the commenter is not receiving those emails, we should get her email address, make sure she's had it.
This question is from Mike Glovin. Can you have the COGCC mapping site work with the NPMS site so we can see all infrastructure regardless of jurisdiction?
I think that's a question somebody else has asked, is how can can COGCC integrate information from other pipeline databases within Colorado, and we'll take a look at it and ask some of our colleagues.
Can you, this is also from Leslie Weiss. Can you please also reiterate the need for clarification by COGCC when precisely wildlife concerns will be addressed in rulemaking? There's nothing mentioned in today's presentation, but obviously the topic pertains closely to flow lines. Please ask how and when this guidance will be issued. Thank you.
Maybe if we can have a quick call with Ms. Weiss, if that would be helpful to talk through and understand. That's what I'd asked from Mr. Chiropoulos was what are your issues? Help me understand.
Okay, and this one is from Wes with no last name. Will there be additional geospatial data requirements for Form 444s that have already been submitted and approved to meet the demand for a publicly viewable map?
Again, I think that those are exactly the type of questions I hope Mr. West, for lack of last name, provides his perspective to us on.
And same also from Wes, will there be additional attribute requirements for Flowline GDB in Form 44 submissions moving forward?
I think that dovetails with kind of the first question about what information is going to be publicly available, what information the agency is going to capture, and that's what we're here to hear from and do and think about. So, I mean, to be clear, we're inviting stakeholder comment because we haven't made firm decisions and we need input from folks about where we're going on this.
Also from Mike Glevin, a technical note, suggests clear clarification of technical requirements of setback rules, since PHMSA setback rules, not called that, are used in different contexts than COGCC intent. The engineering behind the FAMSA rules for liquid lines can be complex and of limited benefit to the community. Consider that more benefit may be gained by focusing on leak prevention and mitigation requirements.
I think his comments dovetailed nicely with Ms. Corvus. So close. So we look forward to hearing more from folks about that. Seeing last call, comments, questions. I'm trying not to like auctioneer this off and create a rush to the end, but so good.
This is from a Denver Post reporter, Judith Kohler. She says, do the proposed revisions cover gathering lines? And does the PUC regulate the gas gathering lines?
It's my understanding that PUC regulates gas gathering in Colorado. Some of the commenters have raised questions about whether the scope of 181 has broadened COGCC's authority, and I will take a second look at that with our lawyers. Going once, or just gone. No, I certainly don't want to cut anybody off if you do have comments. But seeing none, I want to thank everybody for their time, whether online or in the room. I think that these are important issues, and doing this well requires all of us to come together and have these kinds of dialogues. So I look forward to also continuing to hear from you outside of a formal stakeholder meeting if you have specific issues, questions, or thoughts that you think that the agency should be considering, and also how those would work in practice and how those would look as rules. So please do reach out if you are interested in engaging in that way. We have a commitment to have draft rules out in early October, so we will be working hard on these issues over the next month, and so timely input is really helpful for us. And again, the COGCC Flowline rulemaking website will continue to be populated with information, as Mr. Neslin requested, around timelines and providing people the opportunity to engage. That's also where you'll find information about filing for party status for those of you who really just can't get enough of the Flowline issues. So, yes. Let's get you a mic, Ms. Ryan.
Hi, Julia Ryan. The public comment portal that's been set up for all of these rulemakings, there's a line at the bottom that says that the public comments will first be vetted and then available in a few days. And I was just curious if it's the commission's intent to have public comments on all the rulemakings available on kind of a rolling basis, or if they're going to be coming out in batches, or.
I think the review is to make sure there aren't swear words and stuff, not to pick winners and losers about who gets posted, but I think Ms. Larson would be better poised to answer the specifics of your question.
So this is Mimi Larson, the Hearings and Regulatory Affairs Manager. We are going to endeavor to get the public comments out as quickly as possible. So We're not necessarily, we don't have a timeline to have them go out in batches, but we're going to do a consistent review and get them out, push them out as quickly as we can.
Well, everybody gets 14 minutes back today. You're very welcome. But no, in all honesty, thank you all for your time and commitment.